Good morning. Are you Caleb Laskowski?
Yes, ma'am.
And will your client waive the formal reading of the motion?
Yeah, absolutely will, Your Honor.
Get that for Doug's. Mr. Laskowski, in cause number 21-37917, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 3rd of 2022 for the offense of evading detention with a motor vehicle. And that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of possession of a controlled substance February 16th of 2022 in Hardin County, Texas. And is that true or not true?
True.
Count 2 alleges that you committed the offense of possession of a controlled substance on February 16th, 2022 in Hardin County, Texas. And is that true or not true?
True.
Count 3 alleges that you provided a urine sample on March 29th of 2022 that tested positive for methamphetamines, amphetamines, and benzodiazepine. And is that true or not true?
True.
Count 4 alleges that you provided a urine sample April 14th of 2022 that tested positive for methamphetamines and benzodiazepine. Is that true or not true?
True.
And then count 5 alleges that you were behind in your court assessed fees as of April 13th of 2022 in the amount of $315. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before, excuse me, before you signed these, did you go over them with Mr. Crocker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, states 1.
It's admitted. Is there any evidence that Mr. Laskowski is not competent?
None, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. And at this time, also find sufficient evidence to find you guilty. And at this time, find you guilty of evading detention with a motor vehicle. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed. And so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Crocker.
All right.
All right, good luck to you, sir. You can go back to the bailiff. Thank you for being
Thank you,
here.
Thank you, Ms. Smith. Yes, sir. All right.
See, Mr. Brian Lane, you've got Heyman Brandon.
Yes, ma'am. And I need to bring you.
Well, he's here, so we'll,
Okay, hold on, Karen.
you can go ahead and bring him.
What's that, Judge?
You can bring him.
Come
Good morning. Are you Heyman Brandon?
Yes, ma'am.
And this is 21-36605. And it looks like, number 1, Mr. Brandon is charged with first-degree felony offense of murder. And Dr. Rapon was requested to do a competency evaluation. I don't know that we've been back since then. We received that report February 12th.
What?
Over here, February 24th.
All right, so I've already made that
Found him
finding.
competent.
All right, so what's the announcement?
The announcement, Your Honor, is I'm respectfully requesting one more continuance. What I think, after talking with the state, is that we may eventually, at the next setting, request a bench trial. And we're moving into an insanity. I need an insanity evaluation at the time of the offense. So I've got with Dr. Rapon. I'm supposed to meet with him. I
Okay,
just need a little time to get that. The state, after I get that, then we'll move forward and,
okay.
you know,
Do you think he can get that done in 30 days? He's already done the competency. I would
Well-
think he would be able to.
when he came back from the state hospital, when he was deemed competent, I called Dr. Rapon. Dr. Rapon kind of jumped the gun a little bit and thought I was talking about a competency. I already got a competency from, went
Right.
out and did a competency
Right,
and then billed me. But then, so I was like, it's like, hang on a second. So-
Okay.
So he's making an appointment with me. So I anticipate next couple of weeks I'll be to him and he'll maybe.
we'll do 30 days. And if you don't have that back, let us know right before that court date and we can reset it without you guys having to come here if he's in the middle of getting that report ready.
Yes, ma'am.
Okay, all right, you can go back with the bailiff, Mr. Brandon.
Right now, yeah.
See, Mr. Kevin Lane,
Yes, Sean.
you've got Ahmad LeBlanc.
He's in custody.
What is this?
How much?
Ms. Melfino, Ahmad LeBlanc.
Sitting here thinking I didn't notice a nice young new probation officer.
And
Behind her and
all right, are you Ahmad LeBlanc?
Yes, ma'am.
And Mr. LeBlanc was previously in court, entered pleas of true to counts 1, 2, and 3 in a motion to adjudicate and on probation for possession of a controlled substance, a first degree felony. Hold on, that's not right. On probation for aggravated assault. New allegation is a possession of a controlled substance in Chambers County. And I've received the updated report. It was unagreed. Have you both had an opportunity to review the report?
Defense has none.
have your.
Any additions or corrections to the report?
None from defense.
Only any additional that Ms. Shagwa may have from the probation department, Your Honor.
And is this the one I believe Chambers County rejected the charge.
January 28th, Your Honor.
Okay.
Or refused it.
And so, Mr. Lane, you may proceed with argument.
Your Honor, we are asking the court to continue Mr. LeBlanc on probation. He's been in jail in this last time for about 58 days. He did test positive because he had smoked marijuana before he surrendered. He lives with his mother in Baytown. He has no children. He is working at Palmer Distributing, has been employed there for a while and working a forklift. He does do online classes with Southern New Hampshire University for computer training. He does 3D modeling, and that's when he was using with the THCA that he actually got, I think, out of California online that he had sent to him. He's done his community service hours. I think he's done 433 out of 400. I believe he's paid all of his fees. This was his only hiccup. He reported his arrest, I think, the next day after his arrest. And then when the warrant came out, which was, I think, January 20th, he hired me and then surrendered to the court. Your Honor, his mother is here. She's very, very much supportive of him, and I don't believe he'll use any more THC products We are asking that the court, there is another plan to extend him for a year, drop program and another drug assessment. And we would ask that the court follow that alternative.
Ms. Melfino?
Judge, obviously the underlying offense involving a weapon is concerning. However, it looked like it was an issue amongst individuals who knew one another, probably involving some young women as well. Mr. LeBlanc does not have any criminal history. I hate to see him have felony, but he's also exposed to quite a bit on a revocation of this probation. I would defer to whatever Ms. Shagwell has to add, but I would ask that if he's continued, Judge, that he be extended and possibly have something a little bit more intensive than just the drop program.
Anything to add that's not in that updated report from probation?
I mean,
So, I mean, Mr. LeBlanc, you've done so well. I mean, better than most you've done. So the fact that you've done all your community service, you paid your fees, you've reported like you're supposed to. Obviously you understand that you cannot use any type of THC program, THC in any form, whether it's legal here, legal in another state. It's if you test positive, there's no way for us to know if it's legal or not legal. And so you're not supposed to use it. If it's going to show positive in a drug screen, then you can't use it. You understand?
Yes, ma'am.
All right. So what I'm going to do is find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find this counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I think you've come a long way, you're almost at the end of your probation. I'm going to continue you. I'm going to extend you for 1 year. Conditions are going to be that you'll be on the high, and I don't know if he'll still be in Harris County. And so whatever they have that's comparable to what I'm ordering is what you're going to have to do. You're going to be on the high medium caseload. You'll be, you'll be required to enroll in and pay for it and successfully complete the Texas Drug Education offender program. You'll obviously have to test negative. There's going to be a new substance abuse assessment done. If there's any issues that they find that you need more treatment than what we've already saying, then you'll be required to comply with whatever that is. Do you understand?
Yes, ma'am.
Okay. So this wasn't an agreement. So you do have some rights to appeal. You can talk to Mr. Lane about that. And I need you guys to sign this, Mr. Lane, please. But you'll be released, and first thing you do is go to probation and make sure you get everything taken care of like you're supposed to, okay?
Yes, ma'am.
All right, good luck to you, sir.
Thank you.
So we're gonna need this though, once they all sign it, right? So you just, yeah, if y'all will get this, once you get the signatures, if you'll get it back to Kelly so she can get it filed into the case.
Thank you, Your Honor.
Yes, sir.
yeah.
Hey, Judge Walker, you have Paul Nelson.
Yes, ma'am.
Paul Nelson.
Yes.
Yeah.
Have a good day. Doing okay?
Good, how about you?
2 days in a row.
I know. Good morning. Are you Paul Nelson?
Yes, sir.
And will your client waive the formal reading of the indictment in each of the cases?
Yes, Your Honor.
Mr. Nelson, in clause number 23, DCCR 1786, you're charged with the 3rd-degree felony offense of possession of child pornography from January 13th of 2021. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes.
And then in clause number 23, DCCR 1787, you are also charged with the 3rd-degree felony offense of possession of child pornography from January 13th of 2021. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with?
Yes.
In each of these cases, I have here on the tablet some documents that have your signature on them, that the state's marked as exhibit number 1. Before you signed these, did you go over them with your attorney?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I'm required to ask everyone. State, excuse me. State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Nelson is not competent?
None, Judge.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your pleas. Find sufficient evidence in each case to find you guilty. And at this time, in cause number 23, DCCR 1786, find you guilty, sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 23, DCCR 1787, find sufficient evidence to find you guilty, and at this time find you guilty of possession of child pornography. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time, and also concurrently with Montgomery County cases. Is that correct?
Right.
They'll run concurrently with that as well. I'm handing you the trial court certifications. Those show that these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Judge Walker. All right, good luck to you, sir. You go back to the
Judge,
bailiff.
if I
Yes,
may,
sure.
we would ask that the court waive any court costs as he is indigent. If I need to, the court needs me to inquire about that, I'm happy to, but he's been incarcerated for 2.5 years and he has 0 dinero.
What are the typical court cost on a,
200 and something dollars plus this fee, plus that fee. So total in both cases, Your Honor, will be around $550.
what I'll do, let me make a notation and I'll get with Ms. Werner, the other clerk, and find out exactly with the process for that. And take into consideration that he's indigent, that you've relayed that, and I will let you know
Thank you.
exactly how that works and if we can do it. Do you have any issue with regard to that?
I'll defer to the court on that issue.
Okay, thanks, Ms. French. All right, you can go back to the bailiff. Yes,
Have
sir.
a good day.
You'll make a note for me on that, please. Mhm. Mr. Lewis, you have Daryl Burnworth.
Yes.
Good morning. How are you?
All right. Oh, that's it.
Good morning. Are you Daryl Burnworth?
Yes, from Burnworth.
Burnworth, and this is cause number 26 DCCR 0038. Mr. Burnworth is charged with theft of property, and that looks like it's well, it was titled a first degree felony. but it was amended for the value to be of $30,000 or more, not
Right.
300,000. Is that correct?
That's correct.
What level offense does that make it?
That makes it a third degree.
Okay. Then with everyone's permission, I'm going to make that notation on the indictment. I didn't when I amended it, but that way it won't be confusing when anybody looks at it. So I'm going to take care of that. All right. So third degree felony offense of theft of property. So what is the announcement?
Judge, I have been talking with Mr. Burnworth, and there are some questions that he brought to me in regards to his criminal history that went to the offer that was made by Miss French at this time. All of his history is in Louisiana, so I just need to verify some things for her.
Okay.
So if I just get a couple of weeks, I think we'll be able to get this one resolved.
Okay. Any issues, Ms. French?
None at all, Your Honor.
All right. We'll reset it to either 2 or 3 weeks, depending on the dockets. All right. You can go back with the bailiff. See, Mr. Lewis, you have William Miller.
Yes.
William Miller.
And this is Mr. Coleman.
Yeah, I think he's the report came back incompetent.
Correct.
Good morning.
Good morning.
Since I hadn't, the only cases got reset, so I Tom say.
That's nice of you. Good morning. Are you William Miller?
Yes, ma'am.
And this is 26 DCCR 0063. Mr. Miller's charged with the offense of robbery. There was an evaluation for competency that was done by Dr. Grimsley and received that. Okay, the exam date was March 5th of 2026. The finding in that report is that Mr. Miller is currently not competent to stand trial, and that inpatient competency restoration would be warranted for him to regain competency. Is there any other relevant evidence?
Overstood, Your Honor.
Yeah.
Nothing else,
With regard
nothing
to
else from the
competency.
state. No, Your Honor.
Nothing from the definition.
Then based on that and based on the report by Dr. Grimsley, I am going to find that Mr. Miller is currently not competent to stand trial. Order that inpatient restoration is warranted for competency restoration and that he be sent to the appropriate facility for a period of not to exceed 120 days from the day you get to that facility. So Mr. Miller, you'll get sent to a hospital.
Thank you.
And they'll get you taken care of so you can understand everything better, and then we'll get you back to take care of your case. Okay? You can go back with the
All right,
baby.
thanks. Yeah.
Yes.
This courtroom session proves just how unpredictable the justice system can be, where one decision can mean freedom or years behind bars. We watched Caleb Laspowski admit to every single probation violation, and just like that, he was handed a 2-year prison sentence. That's the harsh reality of deferred probation. One slip, and everything comes crashing back with full force. Then things took a much darker turn with a murder case where the defense is preparing an insanity argument, putting mental health right at the center of the fight for responsibility. It's not just about what happened, but whether the accused was even capable of understanding it. And then there's Ahmad LeBlanc, whose case flipped the script completely. Despite violating probation, his consistent effort, working, completing community service, and staying on track, earned him something rare, another chance. No prison, just stricter probation. It's a powerful example of how judges don't just look at one mistake, they look at the full story. From serious felony pleas to competency rulings, this session shows just how layered and high stakes the system really is, where every choice matters and every outcome carries weight. Now the question is yours. Did the judge get it right? Should probation violators be given second chances? Or does that risk go too far? If you found this case as shocking and insightful as we did, hit that like button, drop your thoughts in the comments, and don't forget to subscribe for more intense courtroom breakdowns.